session.
So greetings of the day and a warm welcome from Nivaaran to all the participants joined today from different places, states and countries. I'm Vinita Sahai, an advocate and a mediator of Supreme Court of India, and it's my privilege to be your host today. Over the previous 6 days, our guest speakers have spoken about historical perspective of dispute resolution, conflict management, difference between mediation and litigation, communication skills, verbal and non-verbal, negotiations, agreement, ethics of mediator, etc. And today, we are going to learn the advantage and disadvantage of online mediation. It's a proud moment for me to welcome and introduce our chief guest, Honorable Justice Dr. Sudhir Kumar Jain, High Court of Delhi, who has graciously accepted our invitation to join us today. Sir is one of the finest judicial officers our country has in today's time. His unique sense of imparting justice through balanced approach can be seen in numerous judgments passed by him. Further, Sir has been guiding and imparting training to learned judicial officers and learned advocates since 2002. He has been a resource person about mediation in prestigious institutions such as the National Judicial Academy, Delhi Dispute Resolution Society, State and District Legal Service Authorities, Delhi Mediation Center, law colleges and other institutions, Delhi High Court Mediation and Conciliation Center, and Mediation and Conciliation Committee, Supreme Court of India. Sir has received 40 hours training on the concept and techniques of mediation from Institute for Study Development in Legal System, California, and has further received training of trainers from the Center for Effective Dispute Resolution, UK. He is also an accredited mediator by International Mediation Institute, Holland. So Sir has served as a judge in charge of the Delhi Mediation Centers at Tisazari Courts and Rohini Courts, and was amongst the distinguished members of the Mediation and Conciliation Project Committee of the Honorable Supreme Court of India, prepared a manual for 40 hours training on techniques and concepts of mediation. He has also written several articles on mediation, administrative laws, and other legal issues. For Sir, it can be said that a teacher affects eternity. He can never tell where his influence stops, as I'm sure that even Sir doesn't know the exact number of persons who might have changed their life after receiving any piece of wisdom of Sir. Sir has conducted more than 100 training programs throughout India on mediation and for trainers of mediation. He has also a vast experience in conducting mediation in about 15,000 cases and has settled around 10,000 cases of various kinds of matter in pre-litigation and post-litigation stages. It's an absolute pleasure and honor to have you here, Sir, on 7th day of 4th International Summer School on Mediation, organized by Nivaaran, a body of mediators from Supreme Court of India in collaboration with the Singapore International Mediation Center and Commonwealth Lawyer Association. So with warm welcome, I request you, Sir, to take the virtual floor and grace us with your wisdom. And my sincere request to all the participants to use the chat box for any questions during the session, or raise your hand to ask your question at the end of the session. We enable Sir to answer your questions in an effective way. Over to you, Sir.
Thank you. Good evening to all the participants as well as Nivaaran team. First, I must express my deepest gratitude and thanks to Madam Vinita Sahai for giving such kind introduction about me. I'm very thankful to you, Vinita. I know you since long. And I also extend my deepest gratitude to the Nivaaran team, particularly Shri Sanatan Krishnan and Shri Rakesh Khanna, Senior Advocate, for giving me this opportunity to be the part of this virtual summer school. And I also say my hello to the participant of this program from India and abroad and other partners of this training program. This is really a wonderful opportunity for me to be the part of this program. I feel very much honored for this. You must have learned in the past 6 or 7 days about the various nuances of the mediation. What is conflict? What is mediation? Definition of mediation, different techniques of the mediation like the communication, negotiation, and other related issues. You know, mediation is having its long history, not only in India, but in various jurisdictions across the world. About 20 years back, when Section 89 was reintroduced in the Code of Civil Procedure to 1908 in India, we started to talk about the mediation. For the first time in Indian legal system, the mediation word was used in the statute. Subsequently, the word mediation was used. When we started the mediation in the year 2004-2005, when the Honorable Supreme Court has constituted Mediation and Conciliation Project Committee, at that time, even the definition of the mediation was not known. It was not known to the different stakeholders of the justice delivery system and legal system, how the mediation is to be conducted, whether training is required, or whether mediation is just like any other compromise which we affect in the court or otherwise also. But gradually we started to learn the techniques of mediation, concept of the mediation. If we start from the definition of the mediation, and essential part of the what is mediation in a understanding of a common man, is like a process in which a neutral third person, that is mediator, he facilitate amicable settlement of dispute to be developed by the parties themselves. He uses the technique of communication, negotiation, and other related techniques. So if we go by the mediation process, that various important aspects of the mediation process are gathering of information, right? Thereafter, to gathering of information to understand the factual background of the case, to understand the underlying interest of the parties, right? Giving an opportunity to both the parties to understand the perception of opposite party, then option generation, and thereafter emotional aspects to be addressed, anger management, to understand the emotional quotient of the parties, that is EQ. Also, as appearing from reflecting from the definition, a mediator use communication I just mentioned, and bargaining, and then negotiation, impasse management are also. So all these techniques, if you want to go through the mediation process as written in the various book and literature, it appears that for direct interaction, the physical presence of the parties is required. A mediator has to make a direct contact with the parties, interaction with the parties. There is a trust building with the parties by the mediators. Parties, when sitting face to face with each other, they are directly interacting, directly communicating with each other, and with the facilitation of the mediator, various options are generated. So this is the typical situation, a conventional situation, where the parties are supposed to be present in one room along with the mediator in the physical form, so that there can be direct communication without any barrier. But sometimes the parties, they are not willing to be present in front of each other. They are not ready to see the face of the opposite party. Sometimes the parties, they are residing or available at a very distant place. And more particularly, when in the last 2-3 years, when the entire world faced a very unique situation, that is the pandemic caused by the coronavirus, all the courts were closed, courts were not functioning, the judges, they were sitting at the home, the mediation center, they were closed. It was not practically possible for the parties to come to the mediation center physically and to participate. Then suddenly we realize the importance of something which can be done online. we started our court proceeding online by using the different software available, like Google Meet and Skype and other. We established the contacts with the litigants and the potential contact away from the physical form, like that is through online. And then we started to work, started to function by sitting in our home on our table, on the table and chair of our office. Then we use the techniques, online techniques, so that the idea of access to justice cannot be compromised. Initially, for the some time, the mediation center also remained closed, but suddenly, and we have gradually, realized that this cannot be continued till the time, till further time or till the unknown time. We need to do something. Then we started to conduct mediation online. We developed the software, many software. They are just like we are meeting on the Zoom, Google Meet, etc. So we started to conduct the mediation. Then this, when use of this online platform to conduct the mediation, to interact with the parties, to bring the parties for the settlement, many issues were surfaced, which were addressed. They are required to be addressed, or they have been addressed in different contexts by the different person, right? Then suddenly we have started to talk with the Singapore Convention on the Mediation. In India, we have started to talk on the Mediation Bill 2020, which may soon see the light of the day in the form of act, which also talk about the international commercial mediation, the enforcement of the international agreement arrived at through mediation. So when we had opened the many forum, many things we have experienced in the particularly in the last 2-3 years, then suddenly we realized the use of online mediation. Online mediation, if we understand as a common man, although it is almost similar to the physical mediation, the typical mediation, but online mediation is having something more than the conventional mediation. Online mediation is a method in which the party can resolve their problem. They can address their conflict or dispute with the facilitation of the mediator without meeting with each other physically. It is not required that the parties, they should meet physically. The meeting between the parties can be arranged by the phone call, by the video call, by the email, or any other method, any other software app, by using the internet facilities, by which both the parties may be put to a comfortable situation, right? Then when we develop this idea of online mediation, then we have also started to talk about the various skills of a mediator which he required to acquire before conduct the mediation through online. We know as an ordinary mediation, when I'm doing the mediation in physical form, I need only to know what are the techniques of mediation, how the mediation process is to be conducted. But when it comes to the online, then I must know what are the technological skills which may be helpful for online mediation. As a mediator, we need to have a very good command over the tools which are used or likely to be used for e-mediation, ultimately for e-settlement. We have done successfully in Delhi, in our mediation center situated in the district court, in mediation center of the Delhi High Court. I will give you some empirical data how we could achieve this online mediation, the very big success through online mediation, right? I myself conducted few mediation through online. So then I will also share my own experience, right? But why we need to resort to the online mediation? It should not be because of COVID pandemic, extraordinary situation across the world. It should not be due to the compulsion because of Singapore Convention. It should not be because of this mediation bill, which is likely to take the shape of proper statutory enactment, there must be various factors for the convenience of the parties, for the convenience of the litigant, so that we can resort to the online mediation. I was studying one report. I do not know the authenticity of that report. In India, every year, around 3,000 crores, that is, if we convert into the dollars, the millions of dollars, is spent by the litigants only for the purpose of coming to the court and going back from the court, beside other expenses like wastage of time, legal expenses, coming other direct or indirect losses. It's a very big, very big expense. Although it is not tangible, it is not apparent. But if in the total scenario, if we calculate, if you make an empirical study, how many litigants they are coming to the court, particularly India, every day, you will find the huge amount is spent merely on their convenience, that is by coming to the court and going back from the court. So this idea, then we also notice that mediation process, it should be cost effective also, less time consuming. Why we have started to talk about the mediation? Because of the inordinate delays in the disposal of the case, elephantine backlog of the cases, and most important, the cost factor also. You will find now the litigation is getting costly day by day, whether in terms of the lawyers or advocate fees, in terms of the legal expenses, in terms of other clerical expenses, the preparation of the pleadings, whatever it may be. So litigation ultimate relief should be less time consuming. It should be cost effective. It should, that effective resolution of the dispute must also save the litigants or potential litigant from traveling from one place to another. Like suppose you are having a case before the Supreme Court, and parties, they are staying or residing in the southern part of this country, at the western part of this country, at the northeastern part of this country. Very, very difficult for them to come to the Delhi to attend the case. And if they are able, they manage to come to the Delhi. Sometime we notice that the case could not reach. The court could not find the time to hear the argument or to hear on the merits of the case. Again, it's a very big disappointment for the litigants or for the parties, because they have wasted so much of money, they have wasted so much of the time, how much effort they have put. So then we need to save the parties from excess traveling. Now, if you remember that, and our Honorable Supreme Court, different high courts and district court in Delhi, we are also working online. The litigants, they have been given a liberty to appear in the court or through virtual mode. So that's why how we need to advocate and propagate the online mediation. And then it's also what I understand, sometime, particularly in the joint session, I was addressing the gathering, that in the joint session, in the presence of opposite party, there is a huge outburst. Party lose their temper. If we continue, if we allow the parties to participate in the online mediation, then this kind of stress can be avoided, the tension can be avoided, and their energy can be channeled towards the settlement of the case. And one thing which I always favor is that our legal system should be eco-friendly also. I am very much, everybody knows how I find myself very close to the nature. If we need to decongest the court, we need to, decongest the system. We need to stop the persons, those who are coming to the court without any purpose. And this e-mediation would also help to protect the environment. This would be a comfortable environment, and we would be able to develop a eco-friendly judicial system also. and this mediation center, they are the part of judicial system, integral part of the judicial system, right? What I always propagate, that this online mediation, which what I have noticed, it raises many issues. Just I have mentioned that online mediation may raise many issues also, maybe certain merits, and may it include demerit also. First, it is the basic idea of every system, whether it is a litigation system, whether it is arbitration system, mediation system, conciliation system, counseling system. The basic idea is the access to justice. The poor person, they must have an idea, or they must have a reach to the access to justice. If online mediation is propagated, promoted, then a person who is sitting at a distance place can have easily the access to the justice. Let me share that when it is not like that, we have started to talk about the online mediation for the past 2-3 years. I still remember when Honorable Mr. Justice S.B. Sinha was the chairperson of the Mediation and Conciliation Mediation Committee, the Supreme Court of India. He asked me one day, because at that time I was very active in the mediation and actively participating in the mediation activities. He asked me, Sudhir, prepare a national plan on mediation. I submitted a national plan on mediation, and one of the chapters was devoted on e-mediation for the future. I said, sir, this e-mediation would be one day the time of reality. It would be a reality. We need to develop e-mediation. We need to take the parties from physical mediation to e-mediation. If we want to give a momentum to this mediation, we cannot afford the parties to come to the mediation center every day. We need to make this mediation institution of the mediation to the litigants friendly and party friendly also. Recently, we developed an excellent mediation center at T. Sudhir Court. If you are having any opportunity to visit that center, there are 20 mediation rooms, and every mediation room is having the facility of online mediation, the facility of video conferencing. The parties may come physically and may join the mediation proceeding through online or through virtual mode. This is a choice is given to the parties. That's why we can develop the institution of the mediation. If the system of the mediation is easily accessible to the litigants, to the parties, so they will, start mediation. They will choose mediation not as a compulsion, but as a choice to address their dispute, to address their resolution of their pending cases, as a choice, not as a compulsion. And it would be another issue is which we notice, it is found to be very convenient for the parties also. By sitting in one room, on one table with a computer on your table, you can attend the mediation proceedings, you can participate in the mediation proceeding, you can give your information to the parties, you can tell the factual background of the parties, you can also disclose your underlying interest, why you want to participate in the mediation. You can help the mediator in facilitation of generation of option. You can easily evaluate the options before the final settlement. So you will find this online mediation would be very flexible and convenient. Why? There is another issue. Why? After conducting a mediation, in large number of cases, I have noticed the large portion of the mediator is also wasted. I am using the word wasted, not utilized, in controlling the parties, in controlling the emotions, which they, spontaneously generated after facing after seeing the face of the opposite party. This is a normal and natural reaction. So in particularly the family dispute, matrimonial dispute, even in the commercial dispute, where the emotions of the parties are involved. So then most of the time, the last part of the mediation time is used for controlling the emotion of the parties, or sometimes the parties themselves. If The online mediation is propagated, it is promoted. If it is put into action at a large scale, every mediation center, if it is coupled with or equipped with the online mediation facilities, I think this valuable time of the mediator can be saved. But other issue also, which needs deeper consideration or deeper address by all the person, those who are having, those who are attached directly or indirectly connected with the institution of mediation, that is confidentiality. Two things I always, when I talk about online mediation, I always address two things, out of which first is your online, first is always very important part is confidentiality. We know the confidentiality is the backbone of mediation. Confidentiality of the mediation process can never be compromised. No party can be allowed to disclose what is deliberated, what is negotiated, what had happened in the mediation room, where before the mediator cannot be divulged. Even the court cannot ask the parties or the mediator to come or to appear in the court and to say what had happened in the mediation center. But I have noticed while conducting the few mediation online, there is a breach of confidentiality. There may be the recording of the mediation proceedings also. Another third person who is not required to be present in the mediation may be listening the confidential information given by the parties. Though information may be misused or abused by the opposite party, there may not be the sanctity of the idea and concept of the confidentiality. So in mediation, particularly in family matters, matrimonial dispute and other dispute also, we need to address how to secure, how to preserve the idea and of the confidentiality in the mediation if we are conducting through online. And another things which I have mentioned, I used to mention is just before the start of this talk, I was discussing with Mr. Rajiv Dattaji, Mr. Sanatan and Vinita, is the non-understanding of non-verbal clues. I will give you one example. I was conducting one matrimonial mediation. The wife did not utter even a single word against her father-in-law. Her father-in-law was sitting in the mediation room. As and when he was talking to the mediator, he was looking at her father-in-law. Very important verbal clue, non-verbal clue was given by the wife, that one of the party. Although she has not spoken anything against her father-in-law, but definitely at the back of her mind, she was having a lot of grievances against her father-in-law. If you are able to catch this non-verbal clue, non-verbal message, your line of mediation would change. Definitely. So this understanding of the non-verbal clue is very, very important integral part of the mediation. Without understanding the non-verbal clues, non-verbal body language, facial expression, the way the parties are speaking, the way they are sitting, you cannot understand the real dispute between the parties. And I think if we are conducting the mediation online, I think this confidentiality and understanding of non-verbal messages given by the party, it can be, I'm not saying always, but it can be, there is a possibility that this may be diluted or may be compromised. Then another aspect which we need to deliberate on this is the impartiality and neutrality of the mediator. When the parties, they are directly appearing before the mediator, in the introduction part, a mediator always address or disclose any conflict of interest. The idea of neutrality and partiality of the one is the physical issue and another is the mental issue. It can never be compromised. A mediator cannot compromise with his clout as a neutral person. But what is the guarantee that on online mediation, the mediator will remain the neutral, the mediator will remain the impartial? He may be guided by a person who is not visible on the screen. He may be guided or controlled or influenced by the factor which is not visible, may not be sensed by the either of the parties to the mediation. It may be my apprehension, maybe with basis, maybe without basis, but we need to address these issues also. Then, but despite these 2-3 issues, this online mediation is very effective. You will find in cross-culture mediation, cross-border mediation, you will find these are very, particularly in the commercial mediation, these are very, very effective techniques. I have noticed that this online mediation is very good, like dispute management, workman dispute. It is community dispute also. Recently, I was interacting with the judges, honorable judges of 1 or 2 High Court regarding the mediation. Everybody has talked, most of the honorable judges, they have talked about the community mediation. To develop the community mediation, I think online mediation may be a very effective tool, right? Family dispute, again online, I conducted one mediation. Wife was sitting somewhere in the Bangalore, husband was sitting somewhere in the Delhi, interacting with them. It was a matrimonial dispute, not able to settle the dispute, but able to bring the parties near to the settlement. But in family dispute, matrimonial dispute, I said we need to address the issue of confidentiality, understanding of non-verbal communication, and most important, the impartiality of and neutrality of the mediator also. Like it may be very effective in the IPR dispute also, because no involvement of emotions, no anger, no sentiment, no grief. Only the parties most of the time, they settle for the payment of compensation and besides some other agreement, right? In landlord and tenant dispute also, it can be very, very effective. You will find that the Honorable Supreme Court in AFCON judgment has given the list of the categories of the cases in which the mediation can be very, very effective, right? I notice and find that in all the categories of the cases as mentioned in the AFCON judgment, this online mediation can be very, very effective also. And then consumer dispute also. I have conducted mediation in consumer related dispute also. Those cases were referred by the Delhi district consumer firm also. So I have noticed all these online mediation can be done in the consumer related dispute also. But when we are talking about the online mediation, although it is not developed in this country up to the desired level, we are all working for online mediation. We are promoting online mediation. But in the future also, on the technical aspect, we need to address some issues also. First important thing is the digital literacy of the mediators. Most of the mediators, I have noticed, while posted as judge in charge in many mediation centers, now the part of 2 mediation committee in the High Court, one which is looking after the Delhi High Court Mediation and Conciliation Center, and another committee which is looking after the affairs of Delhi Mediation Center at district courts. I have noticed many mediators, particularly in the district courts, they are not technology friendly. What I suggest, what I submit, when we are conducting now onward the 40 hours training program, there must be a subject on online mediation, how to conduct online mediation with practical imparting of practical knowledge. Because by arranging 1 or 2 talk on the online mediation, it cannot develop in this country, right? For that, we need to do some act, we need to initiate, we need to take some positive steps in reality on the ground so that online mediation can be established. So we need to train our mediator how to handle the online mediation, right? It should be the part of curriculum also. Now, as per the international standard, we have adopted 40 hours training. It can be extended to 5 hours or 50 hours. So then the potential mediators, those mediators, those who are now training from today, they must be adequately trained in the online mediation. And then thereafter, we need to develop the necessary infrastructure for online mediation. I don't know how many mediators they are having, how many mediation center. Don't confine to Delhi. Delhi Supreme Court, High Court, District Mediation Center. This infrastructure is not a big problem. But when we talk about the remote areas of this country, particularly the rural area and other, where even the physical mediation has not taken its proper shape. So for that, if we want to implement mediations, online mediation, we need to develop necessary infrastructure like computers, smartphone, and most important is uninterrupted internet facilities. Nowadays, we are talking about the 5G, 4G. I think soon it will be the reality. Otherwise, without developing the necessary minimum infrastructure for online mediation, it cannot be the reality. Most of the time, I have noticed while doing the online mediation, the parties get disconnected, voice is not clear, there is an interruption and disruption because of poor internet facilities. Sometimes the information given by the parties may not be understood in a right perspective, in a proper context also. So it would be a brutal murder of the mediation process also. If the mediator, while conducting the online mediation, is not able to understand the information given by the parties, which is the basic requirement. So then these are the issues. And then another thing also, I don't know how far it is correct, it is not. Even I have noticed most of the litigants and the members from the legal fraternity, they do not trust the online mediation. They do not trust the online mediation. Still, they believe in physical mediation. There may be multiple reasons. But the parties, when we started in mediation, in the year 2003, when we organized few seminars on mediation to generate awareness, what was apprehension expressed by the judges, those who were parties, they were very apprehensive about the dilution of their judicial authority. Advocates, they were very apprehensive about the decline in their professional income. And most important, the litigants, they were very skeptical about the addressing of their dispute outside the court system, outside the litigation. With the passage of time, the litigants of this country, they have developed a very positive trust and confidence in the court, particularly in the physical form. They feel very confident, they feel being heard, they feel, with some satisfaction that they are appearing physically in the court and they are able to tell something before the judge. Now, if we want to propagate online, we need to develop a very positive trust about the idea of or institution of online mediation. We need to explain the litigants, we need to explain to the advocates and lawyers, even we need to make the mediator, most of the mediator to understand that online is not a dilution to the mediation process. The basic nuances of the mediation process, rather it would be helpful to them in the future also. So what I always suggest, I have taken more than 30 minutes. What I have, now, if we want to develop the online mediation, we need to have three kinds of mediation. First, physical mediation. Second is online mediation. And third is hybrid online mediation. Physical mediation, if it is practically possible, it is convenient to the parties, we need to prefer the physical mediation. We cannot compromise the physical mediation for the online mediation. Although we need to promote the online mediation because tomorrow would be the time of online mediation. Gradually, what I perceive and conceive is that within the span of 10 years, the online mediation will be having its own say, independent say. I think it will take over the physical mediation. So if online mediation is possible, if it is comfortable to the parties, it can be conveniently conducted without compromising the quality of the mediation, then we can go for online mediation. There is no use, no fun to call the parties physically. Even in the court, I always favor that initial proceeding, like submission of the documents, submissions, completion of the pleadings, arguments on the miscellaneous application, where not too much argument is required to be advanced, then the court proceedings must be conducted through virtual mode. Again, we need to decongest the court system. We need to make this ecosystem, this court system eco-friendly. But third, which I always propagate, is the hybrid online mediation. What does it mean? Initially, like for introduction part, for gathering journal information, for understanding of the underlying interest of the parties, to develop initial options, to know whether parties are actually and really willing to go for the settlement or they are ready to explore the possibility of settlement. This part can be up to the joint session, can be conducted through online without calling the parties to the mediation center. But when it comes to the actual bargaining and negotiation, when it comes to the breaking of impasse, breaking of deadlock, when we need to address the deadlock, stalemate between the parties, I think, I may be wrong in my words, then we cannot done away with the physical mediation. We need to call the parties to discuss the option, to deliberate upon the viability of the option generated during the mediation process. So this much, what I always start, online mediation can be start with the simpler cases like recovery matters, 138 matters, consumer disputes, landlord-tenant dispute, workman dispute, like in the High Court also, like the writ petition filed against the award of pass by the labor court. If some landlord-tenant dispute, if a appeal is filed or FAO is filed, first appeal against order is filed in a landlord and tenant dispute. If it is a commercial dispute regarding the recovery of the amount, those matters on practical, on test basis can be referred for online mediation. But we need not to be so much obsessed with the online mediation by referring the complicated and complex dispute for online mediation. They may be settled, may not be settled. I'm not saying those cannot be settled, but it is always better to call the parties in the mediation room for direct interaction with the mediator. You know, as a mediator, when I was conducting in mediation in physical form, many complex issues, sometimes, simpler issues, they are also converted into the complex issue by the parties because of their various psychological factors. So I was able to manage the party, their expectation, their emotion, their expectation about the outcome, their expectation and their misunderstanding what the other party is likely to get, whether the opposite party is getting the big share in out of the settlement. So all these issues which may affect the final settlement, I was able to address with direct communication, not through online, but direct communication with the parties. So now the time has come. We need to introduce the online mediation, but gradually and gradually. The problem is that sometimes we get obsessed by the new idea without implementing with a proper infrastructure, with proper techniques also. Tomorrow may belong to the online mediation, But today, if we want to shift from physical mediation to online mediation, we need to travel gradually and step by step, from simpler cases to complex cases. Now, how this I'm having, before the conclusion of my talk, how the online mediation is effective, particularly after this pandemic caused by the coronavirus. And one thing which is really appealed to me, we did not stop the online mediation after this corona pandemic is over. So it means it was started because of pandemic. Now we are able to continue with the online mediation. In Delhi, online mediation is in practice. Just to give you some ideas, because talk may not be sufficient unless and until things are put into the action. In Delhi District Court's Mediation Center, 861 cases were referred. In 861, which were referred for mediation, the mediation was conducted through virtual mode, that is online mediation, 861. Out of which really delighted me, the 368 cases were settled to the satisfaction of the parties. It means the online mediation is having its roots in our system. It can grow, it can develop, it can spread its tentacles, but only we need to plan in a very systematic and organized manner. 399 disputes could not be settled. 83 cases were found to be non-starter. And one thing which is very important, beside 368 cases which were actually settled, 145 cases were settled which were not actually referred for mediation. So technically, if we see, more than 500 cases were settled through the process of virtual mediation, online mediation. It is not a small number. It is very encouraging. It gives an idea how the online mediation can be successful in future also. And the shortcomings which I have mentioned, like security and private concern, non-verbal clues, mediator neutrality, and 1 or 2 confidentiality, they would be addressed gradually. Definitely, we would be able to find the solution of this problem. These are not very big problems. Those can be addressed by proper training to the mediator, by proper sensitization of the advocates and the legal fraternity, judges and judicial officers also. This problem can be addressed. Now in Delhi High Court Mediation and Conciliation Center, you will be surprised, you will be amazed to know about 3,620 cases in mediation was conducted through virtual mode. 3,620 cases, it is more than 3,000. And these figures are supplied by the mediation center, subject to the verification, not gathered by me, but supplied by, but they cannot supply me the wrong data, right? I'm sure. Out of which 955 matters, they have been settled by the process of online mediation, just near to 1,000 figure. Near to 1,000 figure, if you think, the success rate is around 40%. I think this is not bad at initial stages. And then another alarming factor is that 1,829 cases could not be settled through the process of online mediation. This is again a little bit large number. We need to address this issue. How we can address this issue? When we are referring a case for mediation, at that time, the role of the referral judge is very, very important. He needs to make the parties understand or whether physical mode of mediation would be more relevant, more practical, or online mediation would be more convenient to the parties. If we interact with the parties at the time of referral, making them understand that it would not be proper or it would not be convenient for the parties to come to the mediation center again and again, it is better to resort to the online mediation. I think this message, if comes from the bench, it would carry a long meaning, effective meaning. Because still in this country, I think more than 90%, 95% mediation is court referred or court annexed mediation. Very few cases for private mediation or pre-litigation mediation. I know Vinita belong to DDRS. They are doing the pre-litigation mediation, but I think they are also not doing online mediation also. I know.
Very less.
So this number, like in Delhi Mediation Center District Court, around 400 cases, and in Delhi High Court Mediation Center, more than 1800 cases could not be settled. Although there may be some technical problem in the beginning, but we need to address this problem, how to make online mediation more effective and more workable. Yes, I just mentioned many times, we need to train the mediator in right perspective, and this online mediation must be the part of curriculum. So I can say today definitely belong to the physical mediation, but tomorrow certainly would belong to the online mediation. As I'm sitting in my office, most of you are sitting in your office, you would be conducting mediation while sitting in your office, saving your time, your energy, your efforts, your money also, and not only your money, but money of the litigants. I always said, used to tell that mediation must be cost effective for the parties. It will generate a lot of confidence about the institution of mediation. So definitely, sir, all of you are seasoned mediator, having deep-rooted interest in the mediation. That's why in the evening of Saturday, you can spend your evening somewhere else outside your house, outside your office. Still, you are interacting on the very important aspect of mediation, that is online mediation. So I do have every reason to believe, with your active participation, with your active commitment, dedication, and application, one day, particularly after enactment of Mediation Bill and Mediation Act, this will become more and more effective for the resolution of dispute also. Or one thing in the last, if we want to make Mediation Act, proposed Mediation Act, a reality, we need to resort to online mediation. So, sir, go for online mediation, train yourself in online mediation, believe in online mediation, and make others to believe in the idea of online mediation. So thank you very much. I have taken a little bit more time. I promised to Mr. Datta and Mr. Krishnan that I will finish within 30 minutes because I need to go somewhere else also. But topic is so important, or I always look for the future, because till today we are able to generate the acceptability and credibility of the institution of mediation at different level. Now, legal fraternity and litigants, they have started to accept the mediation, but still in physical form. So we need to make very organized and systematic efforts for acceptability and credibility of online mediation. Also, that will not be dilution of settled principles of mediation process. So thank you very much, Vinita, sir, Rajiv Dattaji, Mr. Rakesh Khannaji, Mr. Krishnan, for giving me this wonderful opportunity. Or I am telling you from the core of my heart, this is my first time I am speaking on the online mediation for such a long time. It's my first attempt. If I said something wrong, so please excuse me for my incomplete information and knowledge. Thank you. Thank you very much to all.
Thank you, sir, for sharing your wisdom. Sir, I have received several questions from our participants, and I'm just reading it for your voice input. So I have got a question from Advocate Kavita in Solanki from Bombay High Court. So she's asking, in mediation, sometimes parties behaves very strange, and when they are very quiet, how to handle these kinds of people?
You know, even though mediation is totally party-centered. I was telling today to the participant in one training program that it is not the duty of the parties to give information. Simultaneously, it is the duty of the mediator to get information. If the parties, they remain silent, then the proper use of the questioning, how to ask the right question from the parties, how to take the parties, In many, many cases, you will find the parties are saying, sir, I want justice, give me justice. That's all. Then there is big silence on their lips. So it is, for the skill of a mediator to take the parties from silence to settlement. This is also true in online mediation also. It is also true on online mediation. That's why I always advocated, as a mediator, you should not skip the introduction part. So it can be handled properly. Yes.
There is another question I have from CDR TR Mohan. So his question is, sir, I have completed my 40-hour mediation training program from ADR ODR UK after getting motivated by attending one of the Nivaaran previous summer school to become a mediator. ADR ODR UK model of training is fully online. So I'm very passionate about mediation as a whole and online mediation in particular. I'm an advocate and an IPR professional, being a patent and trademark agent from Chennai, but I'm yet to break ice of starting my mediation practice. Any leads how to get noticed as a mediator and start my practice? I'm ready to undergo any more training if required. Is there any agency who maintain a list of people who have undergone training as mediators in the country? And if yes, could I get the lead how to join?
Now, I'm very delighted to know that you are interested to choose your career as a mediator also. Till today, except Mediation and Conciliation Project Committee, Supreme Court of India, there is no any recognized authority or body which can give you the certificate in the mediation practices. If you want to become a good mediator, whether it's in physical form or online, then you need to take, I think, training under the aegis and banner of Mediation and Conciliation Project Committee. Now, recently, many private institutions, they have come. They are imparting training in the physical form as well as online training. You are already qualified mediator. Start your practice as a mediator in IPR dispute as you have done in the IPR. And I'm saying that in IPR, if you confine yourself only to the IPR dispute, there is an enormous potential of mediation in IPR dispute. I have handled many cases in mediation pertaining to the intellectual property right dispute. The only resolution which surfaced after deliberation is the payment of compensation and certain condition not to use trademark or copyright in future also. Sir, you may have bright future as a mediator. Continue with your practice, and knowledge is a continuous process. Learning is a continuous process. Everywhere, from any place, any institution, if you are getting some knowledge, you are welcome. Go for the training, refine your skill, go for advanced program, a orientation program, sensitization program, refresher course, whatever may be the shape of knowledge, take the knowledge. It will help you a lot. But I'm very delighted to know you are having enormous interest in the mediation. And maybe I may assist you my post-retirement also.
So there is another question from Aruneshwar Gupta, senior advocate. Question is, can India become hub of international online mediation?
It can. Still, it is not today. What I used to tell to the mediator in my mediation center when I used to interact with them, used to give the example of international commercial mediation. Dispute belong to the India. Arbitrator is coming from Hong Kong and Singapore, where we are very obsessed with Singapore and Hong Kong. And then the seat of the arbitration somewhere in the London. Same would happen to the international commercial mediation also, even the national commercial, high-valued commercial mediation also. For that, we need to prepare ourselves today itself. If we want to grow like an international commercial mediator, we need to prepare today itself. Take mediation training, practice in the mediation, then develop your skill as a good mediator. And then one day, which I think in my humble opinion and humble submission, days are not very far away from today when we started to conduct international commercial mediation. Because I know 3-4 years back, I had opportunity to attend one conference on mediation at Jakarta, Indonesia. I met mediators from several countries, the Southeast Asia countries, European countries, Australia, many other. And I'm telling you, not making any comparison, but all humility at my command, I have noticed the knowledge, the commitment and dedication of the mediators in India is much, much higher than in comparison to those mediation. But we need to break one psychological barrier. Whether I can do international mediation, why not? You can do international mediation. If you can do the local mediation, if you can do the national mediation, why not? You cannot do international mediation. Dispute is the same, mediation is the same. But what we require, we need to develop a professional approach, very committed approach. It is not like, sir, aaj tarikh de dijiye. No. If I fix the case for conduction of the mediation session, one particular session with the party, I need to be available. Unless until there are exceptional circumstances. So we can do some commercial, international commercial mediation that is through online also. Other countries, they are not doing any magic. They are not the magical persons. They are as good as we are good. We can develop a confidence, belief, a self-belief in your wisdom. I can do, just go for the international mediation. I always tell, we need to develop mediation at local level, at national level, and third is the international level.
Yeah.
For local level, 40 hours training program is not required, even 20 hours, some community mediation. For national mediation, we need to be a trained mediation, we need to be experienced mediation. For international mediation, we need to understand the international practices also. For that, like my friend who asked question, raised one query before this question, is it trained from out of India? So you can pursue your further courses, certificate courses, or any other diploma courses in the mediation, in a specialized field of mediation, even outside the court. No, I'm telling you, I got training from the expert, those who came from abroad. They used to tell us, this is integrative bargaining, and used to give one problem without disclosing what is the meaning of integrative bargaining. Gradually, we customize the entire mediation training, which is suitable to our condition. So we can do international mediation. There is no problem, but be ready, be prepared. Preparation is must. You have faith in your ability, in your capacity, in your capability. Have developed faith. Agar mujhe milega, I and Vinita will do international commercial mediation as co-lead.
Thank you, sir. I will be honored. Thank you.
Any other question?
Yes, sir. Reena Chaudhary, she's asking a question. What should be the approach of a law student to becoming a professional mediator in India?
Yes, you have asked very good question, and it will answer for our future potential of the mediation also. Earlier, when I did my LLB, it was just going to the law faculty and coming back from the law faculty. Attended the class or not attended the class, it hardly matters. But now the entire curriculum of the law courses have been changed. Many law courses, they have included, even as per the direction of Bar Council of India, this training on concept and techniques of mediation is now included in the curriculum of many law schools. Our law student, they need to be taught about the mediation during their law course. When they are appearing in the court, when they are choosing their career in the legal field, either as a law scholar, as an academician, as a judge, judicial officer, advocate, lawyer, consultant, whatever it may be, at the very threshold of their career, they must have clear about the utility of mediation in resolution of dispute or in addressing the dispute of the parties. So they can promote, they can motivate, before going to the court, they can resort to the mediation or any other form of alternative dispute resolution. So we need to prepare our law student. I had occasion to address many students of many law colleges. So I used to tell them, you are the future of this country. You need to be prepared today. If you want tomorrow, you need to be prepared today itself. We cannot take the relaxation of even one day also.
Yes, sir. Thank you, sir. Sir, Milani Srivastava, she is asking a question. What is the legality of resolution provided by private online dispute resolution firms in India?
You know, one thing is that we need to keep in our mind that till today, there is no statutory enactment which can govern the various aspects of mediation. Like court annexed mediation, court referred mediation, there is a judgment delivered by the Supreme Court, that is AFCON judgment. That portion is also dealt with how the terms and conditions of the settlement can be executed. This issue before AFCON judgment was addressed by the Supreme Court in Salem Advocate Bar Association case. When it comes to the private mediation, there can be three options. Like a suit, it is mediation settlement is like an agreement. It's like an agreement. It can be enforced by filing a suit for a specific performance. It can be taken as an award passed by the arbitrator or conciliator. It can be taken as the decree passed by the civil court. Now, what I understand, the Delhi High Court Mediation and Conciliation Center, in case of pre-litigation mediation, that is like a private mediation, they are recording in the form of conciliation settlement, which can be enforced under the various provision of Arbitration and Conciliation Act 1996. But one thing is that even if in private mediation, online mediation or physical mediation, if the mediator has addressed the underlying interest of the parties, I think enforceability of the settlement may not be a big issue. But we are still in our society, we are having the crisis of accountability also. Yeah. I have read one study that in our country, there is 97% breach of agreement. So these are certain practical problems. I hope those will be addressed by Mediation Act, if enacted by the Parliament. Otherwise, it depends upon the wisdom of the parties.
Yeah. Thank you.
Just file a suit in the civil court. Let the law be developed on the basis of settlement, a suit for a specific performance. File a suit. Let the law be developed on this issue. As a civil judge, I pass many orders on the basis of settlement. Even back out by one party, even then I passed the degree. I said, let my order or judgment be tested by the Superior Court. Let the law be allowed to be developed on these issues also. At least we need to give some force to the enforceability of the mediation agreement. Unless until we are able to execute the terms and conditions of the settlement, entire exercise would be total wastage of time, as settlement would be like a mere waste paper also. So if any mediation settlement is placed before me, I hardly allow any party to back out from the settlement. Sometimes democracy is required to give way to the dandacracy also. Right?
Yes, sir.
But it depends upon the wisdom of a person who is executing the terms and conditions of the settlement.
Yes, sir. Sir, Nishita Singhal, she is asking a question. Do married couples experiencing conflict consider private mediation before considering separation? Can we say mediation can be a substitute for marital counseling when there is no mental illness issue?
Because counseling is entirely different from mediation. If the married couple want to resort to the counseling, in counseling, a counselor develops a very deep relationship with the parties, an emotional relationship with the parties, which may not be true in case of mediation. So counseling and the mediation, they operate in a different sphere. So if you are having some problem in the marital relationship, the parties can resort to the counseling as well as to the mediation. It can be done simultaneously also. One of the best advantages of the mediation is that it not only restores the relationship between the parties, it also amicably terminates the relationship between the parties. So sometime in the matrimonial dispute, there is amicable termination of the matrimonial relationship. Ultimately, we need to resolve the dispute. It may be by counseling, or in India, there is no much difference between mediation and conciliation. And I remember in a few months back, I was in Jharkhand Judicial Academy for one program. I said, in India, the perfect technical mediation can never work. It is not possible for a mediator not to suggest solution or not to give suggestion to the parties. It's not possible. We need to develop mediation as a blend of mediation, conciliation, and little bit flavor of counseling also. Particularly in the family dispute, matrimonial dispute, where the emotions of the parties are involved. So I said like hybrid online mediation. So we need to develop hybrid mediation also. Dekhiye, we imported the idea of mediation technically from USA and other countries, but we need to customize it. We need to make it suitable to our own condition. We need to develop Indian jurisprudence on mediation also. So what I understand, and I also mentioned in Jharkhand Judicial Academy, a perfect mediation in Indian condition would be the blend of mediation, conciliation, and little bit counseling also. If we are able to develop the mediation in this shape, I think for matrimonial, in a matrimonial dispute, there would not be any problem for the married couple to resort to any forum for their settlement or addressing their matrimonial dispute.
Sir. Thank you, sir. Sarthak Singh is asking, what are the different qualities as a mediator required specifically for online mediation?
Online mediation, dekhiye, we talk attribute, what should be the attributes attached to the personality of a mediator. There is no much difference in physical mediator, a mediator who is conducting physical mediation, or a mediator who is conducting online mediation. I just mentioned about the digital literacy. He should know the technique how to conduct mediation through virtual mode. Otherwise, he should be neutral, he should be patient, he should be active listener. Or one best quality of the mediator, whether online mediation or physical, I advocate he should be very, very diplomatic. You know, diplomatic is a very negative. What is somebody is telling you, madam or sir, you are very diplomatic, it may harm you. But what I consider diplomacy is your ability to take others in your fold. So I used to tell to the potential mediator, first go to the parties and then bring the parties to your fold of settlement by the use of various techniques. For online mediation, no separate qualities or attribute is required. We cannot partition the qualities of a mediator. These qualities are good for mediator conducting mediation in physical form, and these are the qualities essential for the mediator conducting through virtual mode. I don't think there can be any line of distinction between two categories of mediator. Every mediator should be equipped for both physical mediation as well as for online mediation.
Thank you, sir. And I've seen, I think Andrea Gordon has raised I think he wants to say something. Rahul, can you help him to just invite if he wants to say something? Okay, I'm just reading another question, sir, and then he will join us in a minute.
Yes.
The second question is here. It's from Vashuddin Dadini. So, sir is asking how the following aspects are addressed in ODR: place of proceeding, jurisdiction, and enforceability.
You know, mediation proceedings are jurisdiction free, whether in physical form or online dispute resolution mechanism or through online. They are jurisdiction free. If you can settle a mediation in Mumbai while the dispute pertains to Delhi or somewhere else also. Enforceability can only be done as per the law applicable to one particular territory. If the dispute pertains to the Indian dispute, then the Indian law would be applicable. If dispute pertains to law or any other jurisdiction, then that legal jurisdiction would be applicable. Enforceability, it totally depends upon what is applicable, legally applicable or legally available to the parties. Like mediation settlement, whether physical form or online mediation, does not mean that you settle either in the private mediation or in court refer to the next mediation, something which is not recognized under law. So every mediation settlement, what I understand, must satisfy the test of legality and validity. It must fall within the four corners of legal validity. So this jurisdiction, mediation settlement is jurisdiction free. Anywhere you can settle.
And sir, Advocate Vijay Kumar, his question is, what about emotions of the parties that can be settled on physical mediation?
In physical mediation?
Yes, sir.
You know, even in the commercial dispute, family, we always talk about when it comes to the emotion, that we talks about the family dispute among the family members, father, son, two brothers, two sister, different family members, matrimonial dispute. Even emotional angle can be present in any kind of dispute, maybe landlord-tenant dispute, maybe workman-management dispute. Even in the, I have noticed in the commercial dispute also. To address the emotion of the parties is very, very important. That's why I conducted few programs for my mediators in a relationship quotient and emotional or quotient also. As a mediator, first we need to understand and manage our own emotions. Only then we can understand the emotions of the parties present before us also. And if you want to understand the emotions of the parties in a mediation, if you want to address the emotions of the parties, we need to be empathetic, not sympathetic. Empathy is the very big weapon in the hands of mediator when it's come to the addressing the emotions of the party. So emotional issue may be present in physical mediation, it may be present in online mediation. But in physical mediation, what I understand, it is more convenient to handle in comparison to online mediation. Also, because there is no direct contact between the parties. But in physical mediation, there is direct interaction with the parties. Yes, or sir. Between the parties themselves also. Yes, sir. Abhi, if you understand me today, how the emotions can be understood, today I was giving one example in the, आप लोगों ने जंजीर फिल्म देखा है? जंजीर में that hero of the film was fighting against the liquor mafia. Out of the conspiracy, he was terminated from the service. He is very emotionally charged. He want to, he want to beat everybody. Very disturbed, emotionally charged, very hostile. He is sitting in a room with his fiancée Jaya Bhaduri. So one painting is hanging on the wall. What the painting was displaying, a tree at the corner of a lake. Then ज्वाला that वो जया भादुरी कहती है, पहले यहाँ एक ज्वालामुखी था, वो फटा, उसका लावा बह गया और आज वो ठंडे पानी की झील में बदल गया. तो as a mediator, you need to address the volcano inside the parties, allow them to vent, and then convert the volcano in a lake of a very sweet and cool, drinkable water. That is up to the skill of a mediator, how you address the emotions of the parties. So there is no difference in online mediation or physical mediation. Emotion is emotion. If I am talking through online, it doesn't mean that my emotion, my reception would be different when you would be meeting physically with me or in person with me, right?
Thank you, sir. Sir, Advocate Savio Travaso, and he's asking a question. That my question is, can we expect a bridge between the judiciary and private trained mediators, which will help to reduce the number of petty cases, which can be easily settled by talented and skilled mediators?
Yes. In Delhi Mediation Center District Court, we are able to settle more than 250,000 cases. In High Court Mediation Center, we are able to settle about 20,000 cases. It means those cases, although at one point of time, they were the part of the docket of the court, but with the little bit activism on the part of the adjudicator, cases were referred for mediation. they were addressed in the mediation center by the trained mediator. Ultimately, parties preferred to resolve their dispute. In AFCON judgment, the category of the cases are given in which the mediator, those cases must be referred for mediation. And we always forget another important direction given by the Supreme Court in AFCON judgment is that every court is required to consider in every case whether this case is suitable for ADR or not. If it is suitable, refer the case for ADR. If it is not suitable, then record the reason and proceed with the trial or further proceeding, whatever it may be. So every case which is pending in the court is having potential for settlement, unless and until the judicial verdict is required to be given on some important question of law. So try the mediation. Most of you are the advocate. If the judge is not referring the case, you can make a humble submission to the court. Sir, kindly refer the case for mediation. Let us try to explore the possibility of settlement, whether the case can be settled or not. So every case is having if we are able to settle the cases, ultimately it would reduce the burden or load on the case, and judicial attention can be given to those cases which really requires the judicial attention of the adjudicator. So it is very collaborative efforts that we can say mediation is a collaborative exercise. So entire mediation institution is again the collaborative exercise, different stakeholder, litigant, judges, academician, government, judicial officer, litigants, all they are the part of this institution of mediation.
Thank you, sir. Sir, here is a question from Riti Gujral. She's from Dehradun, I think. She's asking, how can I get a platform to practice as a mediator as I already practicing advocate in district court in Dehradun?
You are in the Dehradun. You want to become a mediator. What I understand from the question, you are practicing advocate. I still remember I myself conducted many training programs in Uttarakhand Judicial Academy for advocates and judicial officer. If you want to become advocate, approach to your legal service authority. They may select you. They can send your name for training also to the concerned authority. Otherwise, there are now number of private institutions. They are conducting the training in mediation. So you may be trained as a mediator. What I understand, you want to become a mediator. I hope I rightly understand her question.
Yes, sir. Ajay Pratap Sharma, his question is how to ensure integrity and accountability from mediators. What sanctions can be imposed on mediators? Are any undertakings taken from mediators before certifying them as a mediator?
You know, when we were talking about the national plan of mediation, today we are selecting good persons as a potential mediator, but tomorrow some undesirable element may sneak into the institution of mediation. Ethical issues is going to be a very big problem in future also. The code of conduct and ethical principles to be followed by a mediator. No undertaking, I think it would not be appropriate to take any undertaking from the potential mediator about his future conduct, but we can lay down a code of conduct and ethical principle even on the judicial side, even in the mediation bill also, mediation enactment also, even by the mediation and conciliation project committee also. So there should not be any compromise on the quality of mediation process also. I am strongly in favor of putting sanction against the erring mediator. When I was judge in charge of the mediation center, we came to know that one advocate, one mediator, during the pendency of the mediation, he appeared as an advocate for one of the parties before a court. His name was removed from the panel of mediator. In mediation and conciliation rule, there is a specific provision for removal of mediator. There is a specific provision regarding the ethical principles to be followed by the mediator. So we cannot compromise on this issue.
Okay. I have a list of questions, but because of the time, sort of time, and it's a time to close. So I will just thank you so much for this very, very informative session. And we learned a lot from you today. And our sincere thank you for taking out for your precious time from your busy schedule to share your insight, knowledge, and experience about mediation, sir. A subject so very close to your heart. Sir, we look forward for more opportunities to get connected with you and enrich our knowledge. So I also want to thank you, all the participants, for your active participation and cooperation. And a special thanks to Rahul, who is a backbone of our online mediation and supported a lot for this entire program. So we look forward to meet you all participants tomorrow at 5 p.m. to learn more on mediation advocacy with Mr. Duncan Turner, Advocate Johannesburg, South Africa and Chair, Mediation Division, Arbitration Foundation of Southern Africa, which will be hosted by Nidul Agarwal. So thank you so much. You all have a wonderful evening and God bless. Thank you.
Thanks to
Thank you,
all.
sir.
My
Thank you.
namaskar, very big namaskar to all of you. Thank you very much.
Thank you very
sir.
much,
Thank
sir.
you.
Absolutely
Thank you,
wonderful.
everybody.
Really
And
grateful.
let us make India as the hub of international mediation.
Yes, yes.
Certainly.
Why not, sir?
Let us earn in dollars, enough in rupees now.
Yeah, definitely, sir. Definitely. One should.
Thank
Right. Thank you.
Thank you.
Thank you, sir.
you, sir. Thank you for your time.